Um, Good
Yes.
evening. I'd like to really welcome Mr. Kunal sir. Thank you so much for joining in for this session. For the audience, I'd like to briefly introduce him. He is the founder of Tandon and Company, and he has an experience of more than 14 years. He has been working in different areas such as corporate transactions, foreign exchange and management, media and entertainment, and one of his areas where he has an expertise is banking and finance. And this is where today's topic also comes up. So as we all know, today's topic is about insolvency and bankruptcy of firms and individuals. So without further ado, let us just let's start with the session, and I'd request Kunal sir to please take the session ahead. Thank you so much, sir.
Yes. Thank you very much, Akshay. So our session today is basically on part 3 of the Insolvency and Bankruptcy Code. It relates to insolvency resolution and bankruptcy for individuals and partnership firms. Partnership firms which are registered under the Partnership Act. So this is what we are going to deal with. So it is more or less like the earlier corporate insolvency resolution professional only, which we discussed in the earlier round and the first session of ours. However, the role of the resolution professional here assumes a bit higher importance in the sense that the adjudicating authority under this part seeks a report from the resolution professional at the initial stage itself, whether the individual or the partnership firm should be admitted in bankruptcy or not. So while the other part is insolvency, this is the bankruptcy part of it. So I'm going to discuss that aspect also, and then we will discuss the remaining parts, how the person, whether he agrees to the repayment plan or not, how does all those things take place. So we will display a presentation for you, which it'll be easier for us to take you through that presentation as to what exactly is the situation under part 3.
Yeah, I think I'm there.
Yes. So going to the first slide, which is the introduction. So part 3 is basically divided into 7 chapters. First and foremost, let me tell you that each part of Insolvency and Bankruptcy Code is like a enactment in itself, because each and every provision, including the definition section, is provided in different parts. So while these are different parts of the code, however, it has to be seen as a full enactment, one provision not applying to the other. It runs from section 78 to 187. There is something known as the fresh start process. So this fresh start process is section 80 to 93, which has basically not been notified. The existing provisions of part 3, which have been notified, were notified on 15th November 2019 and came into existence from 1st December 19. So basically, this is what different chapters are. I think we can move on to the next slide. It gives a different, different breakup of the sections. So we come to the same questions as we came earlier: who, when, how, and what is the criteria. So who can sue? Firstly, either the debtor himself can sue or the creditor can himself go under 94 or 95. So if the application is by the debtor, then the application may be for any default committed. The minimum threshold provided is 1,000 rupees. Well, I don't think we should go into the minimum threshold right now, because as and when things start working under this particular part, I am 100% sure that this 1,000 rupees will be enhanced to some higher level. A debtor, however, will not be eligible. Of course, I'm sure you must be aware that debtor, if he himself is an undischarged bankrupt, he's undergoing a fresh start process or undergoing an insolvency resolution process or a bankruptcy process, etc., etc. So section 78 deals with the default when it is more than 1,000 rupees. These definitions are there. What is a debt? What is a default? What is a partnership debt, etc., etc. I don't think I need to go into so much detail. So this is basically the framework. Now we are going to give you the flow chart as to how it is done. So firstly, you file an application like you used to do in a corporate insolvency resolution process. The difference in this process and the CIRP is that the moment the application is filed, the moratorium period commences, because the reason is that this particular section says that once you have filed it, no property of the company, assets, etc., should go out of the hands of the individual or the partnership firm. Then the claim is registered. Once the claim is registered, we come to the repayment plan. A chance is given where the individual or the partnership firm can come up with a repayment plan and the meeting of the creditors take place. So let me just stop here. The main purpose or the objective behind the code, as I said earlier, was and is that it is the creditors in possession and not debtors in possession. So when I say creditors in possession, is that it is the creditors, after the process is initiated, they take over the entire process, etc., of the entire insolvency resolution. The debtors are actually told to stay out of it and not intermingle with the entire process. Then the creditors approve the payment plan and the adjudicating authority passes an order on that payment plan. After the payment plan is approved and the adjudicating authority accepts that payment plan, obviously the implementation happens. And if implementation happens, the resolution professional is discharged, and even the individual and people, the partnership firm is also discharged. Now, what happens in case of filing of application by debtor or creditor? Though I've given a basic gist of this. Commencement of moratorium period. During this period, any legal proceeding pending against any debtor, any debt will be deemed to have been put on hold, and the creditor of the debtor shall not initiate any action against the debt. If the application is made in respect of a firm, the application will operate against all the partners of that firm. The registration happens under 103, and then a list is prepared of all the creditors within 30 days. Then, of course, comes the repayment plan, the meeting of the creditors, approval of the repayment plan by the creditors. Then we go to the tribunal who accepts it. Now, one more important fact is that the adjudicating authority over here is not National Company Law Tribunal. A very important distinguishing factor. It is the Debt Recovery Tribunal, which has been made the adjudicating authority here. Then completion of repayment plan. Resolution professionals will forward the following information to the persons who are bound by the repayment plan within 14 days of the completion of the repayment plan. Notice of repayment plan being fully implemented, and a report summarizing all receipts and payments in accordance with the repayment plan. Then the resolution professional is discharged. Now, what are the rights of the creditors in the meeting? Obviously, all creditors have a right to vote. This is the third distinguishing factor, that over here the word used is creditor and not financial or operational creditor. As you are aware that there is a distinction between a financial creditor and a operational creditor in the CIR process. In this case, the creditors has been defined as including secured and unsecured creditors. So all kinds of creditors make secured credit, make the committee of creditors. Voting shares are decided in the same manner by the resolution professional, and no voting right shall be given to a creditor who is not mentioned in the list of the creditors. So who can sue? We've already discussed this. A creditor individually or jointly, or debtor himself can voluntarily go and seek bankruptcy. If the adjudicating authority previously passed an order against the debtor's request for insolvency saying debtor was filing such request to defraud his creditors, if the adjudicating authority rejects the repayment plan, in all these three cases, we proceed towards the bankruptcy of the individual or the partnership firm. Here you see how it is done: filing of application by debtor or creditor, commencement of moratorium period, appointment of bankruptcy trustees, order of bankruptcy, control of debtors' assets, creation of list of creditors, distribution of the debtors' estate, discharge of bankruptcy trustees. So this is the process how everything is done. So the first part was really like insolvency, CIR insolvency process. And second part is like a liquidation process, as you can, if you can relate it to the CIR process. So again, this is again how it is done. It is done by filing of an application by debtor and creditor. Our next few slides are going to explain the entire flowchart which we explained in slide number 14. So Kanika, you can just show them the slides. What are the consequences firstly?
Yeah.
Now, consequences of bankruptcy are rather substantial. And in fact, I would say that it is nothing less than, like we say, it is a civil death of the company. In this case also, it is actually civil death of the individuals, because then individuals cannot act as directors, they can't be elected to public offices, acting as trustee of a trust or estate, being appointed as a public servant, member of public authority, can't take any future debts, literally meaning that he is left completely out of public life is what I would say. So it's kind of a civil death. Now, what are the rights and duties of a bankruptcy trustee? It is basically to investigate, distribute the estate, sell any part of the bankrupt estate. Bankruptcy trustee basically acts like a liquidator in case of CIRP. So he has similar kind of powers. So liability of personal guarantors to corporate debtor. Now this is an interesting part of this entire insolvency code, because there are personal guarantors to the transactions, financial facilities which are taken by companies. So personal guarantors are also liable to be put under insolvency. The only distinction between the process is that if the company is in bankruptcy proceedings before NCLT, the proceedings in respect of personal guarantors also must go to that same NCLT. So to the extent that these personal guarantors are there, if they are personal guarantors to corporate debtors, then the process which is taken over by NCLT and not DRT. That's the main distinction here. Yes, Kanika, we can move forward. So provision pertains to corporate debtors similar to those for individual and firms. Who can sue? The insolvency process may be initiated by the corporate debtor himself or by creditors or through a resolution professional. When can he sue? When there is a default of 1,000 rupees or more. The process is more or less the same, which is followed for other individuals and partnership firms. I need not repeat it. Entire process is the same. You have interim moratorium, extended moratorium. The resolution professional has to come and say whether the petition should be admitted or not. The same process of repayment plan is attached, etc., etc. Now, CIR versus insolvency process against individuals and firms. So I have more or less told you what are the distinctions. One distinction is that the amount over there is 1,000. Amount here is 1,000 rupees. Over there, it used to be 1 lakh. Now it is 1 crore. It has changed to 1 crore. There are other distinctions. One is the tribunal. Tribunal over there is NCLT. Over here it is DRT. except in case of personal guarantors. Yes.
Then I think, sir, the only point left for us to discuss is like in brief, the litigation that is going on before the Supreme Court,
Yes.
which has just transferred to itself all the petitions pertaining to personal guarantors throughout the nation.
Right. You can take it forward, Kanika.
Yeah. Yeah. So, okay, I mean, I'm sure you must all be aware by reading the news and everything that recently, it's a very recent development that the Supreme Court has now transferred to itself all the petitions that were going on in different NCLTs, NCLTs in respect of disputes raised by the promoters. I mean, that is like the personal guarantors in respect of the litigation initiated against them. So who are the personal guarantors? People, you must already notice that whenever a bank is giving a loan to a corporate, they usually and typically, to bind their promoters, who are like the shareholders and directors, they take personal guarantees from each of them to secure themselves. So now what has happened is, after 2019 December, when these provisions were notified, the banks have been really active in simultaneously suing the personal guarantors along with the corporate debtors themselves. And while doing so, the promoters have actually challenged that on different grounds, the major ground being that we cannot be sued for something that the board of the company has defaulted in. And of course, all these arguments, because given that there could be a conflict of opinion in the different tribunals and appellate tribunals, Supreme Court thought that it's best decided by them that, as in when can the petition be initiated against the personal guarantors, on what grounds, on what default. So yes, these are all questions which are sub judice right now, and to come to any conclusions or reports about it will be a little premature. So that, I think, broadly sums up our today's presentation. We haven't consciously covered the procedure of fresh start, because that is something which is a little different than the topics that have been covered today, because these were more in sync with the corporate insolvency, which we already did in the last session. And today we thought it will be easier for us to correlate these particular subjects with the previous ones. Now, again, in this section also, since these provisions have not been notified yet, there is no litigation as of now. So anything and everything is almost an academic question. Any questions or loopholes that we may feel are there in the whole procedure are academic and can only be at best gauged from the bare language of the text and judicial precedents, as the IBC is still growing, even with respect to the provisions which were notified in 2016 itself. So these provisions, given that they are not even in practice right now, yes, there is a lot of room for improvement and development, is what I'd like to sum up with.
All right, we have a question here. If any of you would like to take this, Krishna Sharma asks, if there is no CIRP against a corporate debtor, and lenders want to initiate a personal insolvency against a personal guarantor first. First, can lenders initiate such proceedings? And if yes, who will be the adjudicating authority for the same?
Kunal sir, would you like to take this, or should I take this up?
Yes. So according to me, as the section reads is that only if there is a pendency of a insolvency before corporate debtor, then things go to, then they go to the NCLT. But if it is not pending, and Kanika can correct me if I'm wrong, if it is not pending in NCLT, then it will not go to NCLT. It will go to the DRT.
Right, right. So is the floor open for questions now?
Yes, we can take it.
All right, so this was one question we had. If you have any other question, any other doubt, please use this Q&A box, which is here just beside the participant button. And you can also put your questions in the chat, both works. So please let us know your questions and we can take them one by one. Swapnil, if you would like to, repeat something, or if you were not clear with something, we can request, for an explanation. Please let me know in the chat box.
Also, Akshay, I would be happy to share the PPT with you, and then you can share it or view it to the participants as and how you like it. Whenever, I mean, like however you want to proceed with that.
Right. We'll try the best possible way to check if we can do that.
Yeah.
And we can go ahead with it.
Yeah.
Do we have any questions?
As I said, it's all in the book right now.
Right. We can just wait for 2 more minutes, and if we don't have any question, then I think we can conclude the session then.
Yes, please.
Guys, please feel free to ask for explanation if there was something which you couldn't grasp or something like that. There is a request, if you may please throw more light on situation of personal insolvency against personal guarantors first, then against a corporate debtor. Do you think this is the right approach if done by lenders?
So as I said, while I was concluding the discussion on this question is actually before the courts. And for us to actually come down to conclusion will be very different. And yes, in different cases, I can tell you one thing as a lawyer. I mean, if I was to argue, it will vary from case to case. For example, the language of a personal guarantee will have to be seen in a particular case. One can be automatic, another can be if the company defaults and then it is actionable. Then of course, first of all, the lender will have to show that it has taken all efforts against the corporate debtor, and then it is coming before the after the personal guarantor. But usually it is automatic. I mean, it's like a simultaneous liability. Mostly the wordings are such that it's a simultaneous liability. This is precisely one of the questions that the courts are still deciding, that whether the lenders can proceed not just against the personal guarantor at first, but can they even proceed against them in a parallel along with the corporate debtor. So that's actually before the court. So to conclude on it will not be right on my part.
Another request, if you can shed some more light on the case pending in Supreme Court on invoking personal guarantees in case of corporate guarantees. What is going on in that trial? When is the next
So
hearing?
since Supreme Court recently only transferred the hearings to themselves, they are going to next hear it. I think the first substantive hearing is going to be on 2nd December as it is scheduled for now. We still have to see. I mean, it's recently come to the Supreme Court, so we are still on logistics, and there is not much of argument available that we can share with you or discuss with you as to what each senior for a different party has been arguing. So let's see, when the next substantive hearing comes, we'll try to update you guys.
All right, we don't have any further questions as of now. Since we are not getting any questions, I think we can conclude this session.
Sure. It was a pleasure talking to all of you people. And I quite understand. I mean, if we were a little fast, I'm really apologetic for that. But honestly, I mean, we tried to make it in a manner that, we could link it with the corporate insolvency, because that's something we covered the last time, and we didn't know if we'll have similar participants. We didn't want to repeat each and every step in as much detail as we did the last time around. But I'm hoping in a repeat telecast, if it's available, you will be able to get more of the stuff that we had on the PPT to tell you a bit more detail about the steps in the presentation slides.
All right. Thank you so much, Kanika ma'am. Thank you so much, Kunal sir, for taking out your time and being with us. It's absolute honor to share, this platform with you. Thank you so much, every participant, for showing up for this webinar. I wish you all good luck in your careers. Thank you so much, everyone.
Thank you, Akshay. Thank you, everybody. Good evening.
Bye.